Hello everybody, the Column of Curae is back with another video session on oral round tips in Moot competition. Today we are extremely glad to have Mr. Tushar Behl as our speaker, who is presently an advocate and working with Justice Abhay Manohar Sapre as his research associate at Supreme Court of India. He was part of several prestigious Moot competitions and had also qualified Best Team Coordination Award 2nd CTCL NLU Delhi International Insolvency and Bankruptcy Moot Competition 2018. Mr. Tushar has also received runners-up, Best Memorial and 2nd Best Advocate Award Surana and RGNUL International Moot Court Competition 2017. Today we will be touching every techniques and issues which need to be dealt while speaking. We are extremely honored by his presence. Now we will ask Mr. Tushar to go ahead with his session.
I'm really appreciative of the fact that the Column of Curae is doing enough to spread awareness amongst the budding movers right now. And I'm here to express my sincere thanks to the Column of Curae and all my listeners here for their active participation. Since I've already viewed 3 of the videos which were there in the past, which was made by my friend Sonak Rajguru, I clearly appreciate his work as well. And I assume that all of the basics have been cleared with regard to the voting, and my session will be totally divided amongst how do we, ensure that an advocate speaks well in the moot court rounds. And I would be focusing much on the basic oral advocacy aspects as well as the advanced oral advocacy aspects, where I'll be simultaneously answering questions which I have recently encountered during my moot court competitions, and as well as specific instances where I have been actually exposed to how a student advocate should, prescribe towards a moot court competition and proceed. So I'll just start with the basic advocacy aspect, where I'll be covering the basic court etiquette and mannerism and the basics of the moot court. So basically, what you need to understand before proceeding to the oral rounds is that after the memorial making stage, one should be always clear with how their speech has to operate, because it is very essential that you should be making a speech well before the moot court memorial submission is done. When we approach towards a moot court competition, the language of a courtroom is very different from what is used in everyday speech. And you should try and formulate phrases as you might expect a judge to say them. For example, colloquial phrases such as okay and all right are not acceptable. These are very informal phrases. And if a judge corrects your mistaken interpretation of a case, the correct response would be something like, I am very grateful for your lordship's assistance, rather than okay, simply okay, which takes me to the fact that how do you address the bench? So in national moot court competitions, you actually address the bench as your lordship and your ladyship respectively. And if you are in an international moot court competition, the same goes for your excellency. When we talk about arbitration moot court competitions, we generally refer to the bench as Mr. Arbitrator, Madam Arbitrator, and if there is a president there in the tribunal, for example, if it's an investment arbitration moot, you refer to the president as Madam President or Mr. President. That's how you should address the bench, and thanking people is always a good idea. And even if you would rather throttle them, because it is also professional to ask the judges permission at various stages of the speech. So, for example, when you start your speech, you should be always inclined towards asking the judge before that, for example, with your lordship's permission, I would like to move on to the statement of jurisdiction. That's how you take things slowly, and the judge always knows that yes, I am being respected here, and therefore you get immediate attention from the judge. As such, you should never tell the judge what you think, because or suppose or suggest, because you must be merely submitting humbly that the judge should always adopt your interpretation of the authorities given. The speech which the advocate formulates should also give the full citation of a case as soon as it is mentioned, and the advocate should always ask the judge if he or she would like a summary of the facts before the case. It is always appreciated that the judges are always known about the facts of the case well advanced, but it depicts your positivist approach towards a moot court competition and your confidence when you actually ask the judge beforehand if he or she is aware of the facts of the case in advance. So basically, let me come on to the basic court mannerisms and the etiquette and style there. So at all times, when I actually mention about the fact that the judges have to be referred to as your lordship and or your excellency with respect to the international moots. There are certain pointers which I would like you all to note. So basically, it's about dressing. You should not dress to impress because it's not a wedding or a function. It's a basic courtroom proceeding, so you should be very formal in your approach, and you should limit shifting around and excessive hand gestures while at the podium. You should be very firm while speaking and shouldn't use excessive body language. Many competitors keep their hands on each of the podium to prevent this. It's a very basic technique to keep your hands on the podium while arguing so you do not fidget while you are speaking. You should always approach your oral argument as a conversation with the judge, not a lecture or a rote learned speech. Because if you engage in the exchange of ideas with the judges and respond to their concerns and do not read the speech as it is, you will surely get brownie points. You should be aware about that any time during the argument, the judges can always interrupt you with questions, and it is very vital that you fully answer the question to the best of your abilities when the judge asks this. Do not tell a judge that you will answer that particular question later in your argument because wherever the judge leads you, even if that means that it's not following your present argument as you planned, you do not have to worry about it. Don't let this aspect of the moot court competition frustrate or distract you, because the part of the moot court competition is adapting and taking into consideration the judge's concerns, because you are merely facilitating the judge. It is the judge who you need to convince. So while finding the time and opportunity to still voice the important parts of your argument, you should also take care about the concerns of the judges. And wherever the judge takes you, you should be prepared for that. I will be later focusing on this aspect as to how do you tackle the judges. But before that, let me just talk about how you need to answer the question. So if a judge asks you a simple question where there is an answer to a yes or no question, answer first yes or no, then also elaborate, because you shouldn't be actually giving them objective answers. If a judge asks you if there is any concern there, you should always reply with an example such as, yes, your lordship. In fact, this is the case where the plaintiff has been accused of this. For example, you need to always be subjective there. So the third aspect here is that you should never speak before a judge, because when the judge starts talking, you should stop talking immediately, even if it's disrupting your flow of the argument. Because even if he or she has interrupted your mid sentence, it is okay to form in a respectful disagreement with the judge, as long as you can back your position up with a well reasoned argument. So, for example, if you are not really well versed with a judge's argument or maybe the judge's question, you can always say that I beg to differ, your lordship, or I beg to differ, your excellency, but the concern of the court is here. So you don't say that I do not agree with you. You just say there is a term there and you use this term, I beg to differ, your lordship. At the end of your presentation, the judges or the bailiff or the court bailiff would be there, who will also show you a stop card. Once you see the stop card, you should immediately stop talking. It is not a matter of fact that if you are left with a couple of arguments, you will be keeping on speaking, because this loses you points if you are not well versed with the time duration. Because you need to keep that in mind that when you are still speaking, when you see the stop card is being presented, the court may finish your thought or stop saying your. You can also say that to the judge, while if you still have a pertinent point to mention that, with your lordship's permission, may I briefly conclude? In that way, most of the judges give you extra time. But if you are so adamant right from the start that you won't ask the judge's permission for that, it will be a major turnout. So once you finish your entire argument or run out of time, thank the court and sit down. The basic aspect of this is that when you end your argument, you should never turn your back to the judge while you move away from the podium. Always you should take a few steps backward, go down to the judge, and then slightly move away from the podium. That's how you should end your speeches. Well, that was all about the basic advocacy aspect. The advanced oral advocacy will be concerned about more of how you should structure your arguments and how you should speak forwards. You should slow down, because you should never speak very fast or maybe very slow. You should make an eye contact with the judge and watch their pen. This is a basic tip and a strategy which I always face in my moot court competitions, that If you are so engrossed in your speech and if you are not in a position to actually view the judge's face and you are not making an eye contact, you cannot actually gather of whether the judge is actually convinced by your arguments or not. If they are taking a note and they are making a summary of your speaking skills, you should speak slower so they can write down all your winning and brownie points. Advocacy is basically all about finding your own voice. Different people have different styles, and some are scholarly and understand, others are more flamboyant. So it's a good basic rule that simplicity is very best when it comes to the art of persuasion, because you need to actually avoid unnecessarily complicated language and be in simple conversation terms. Like I mentioned before, it should be a basic conversation with the judge and exchange of ideas rather than rote learning a speech and actually reading out like a lecture. A good advocate should also be afraid of silence, should not be afraid of silence, because use it for a dramatic effect when presenting a particularly crucial point. A strategically timed sip of water might be a powerful and cunning strategy because, for example, if a judge asks you a very critical question of which you are not aware of, it's not a concern. The judges always appreciate if you take a minute to pause and answer your question, because that shows that you think about the question and answer pertinently. So you should take a sip of water and think about the answer. Ask the question again if you're confused, whether you are not so clear about the question of the judge. And if there's any tip I'd insist upon, it's never ever talk while the judge is talking. And you should always not argue with the judge. Rather, wait for the judge to complete his or her sentence, and then you can respond towards that. So let me just start with how you create and briefly outline your argument in the moot court rounds. So basically, outlining your argument is basically outlining on a single sheet of paper or on the inside of a folder that will be open in front of you on the podium. Some of the mooters do, they have a 20-30 page speech. And some mooters, this is coming out of personal experience because personally, I used to carry a single sheet of paper where I had my brief arguments and pointers, and I had supporting legislations as well as case laws for the same. I only carried a one-page document to, save time and, be a bit more efficient and effective in my speech rather than blindly looking at my speech again and again and referring to it. So oral arguments are supposed to be a conversation between you and the court. It should be an interchange of ideas like I have already mentioned. So this means that you want to make as much eye contact as possible rather than getting engrossed in your speech. If you want, you can write down your introduction as a bit of a security blanket. But if you have time, it can be helpful to memorize the first minute or so because it will give you a settled feeling at the beginning. So as they always say that the first impression is the last impression. So if you are very much crisp, confident, and very much fluent and flexible in your first 2 minutes of your argument, which is the opening statement, you've already won that round. In your outline, near the top and bottom of the page, you can always sure to include exactly what you are asking the court to do because that comes very much important when you are concluding your argument, which is also called the prayer, which I would later focus on. So let me just jump straight to the fact that how do you prepare for your argument? So before moot court competition, imagine that the moot court memorial submissions have been done and there are 10 days remaining for your moot court competition. So the question straight away pops up that what is the best way to actually prepare for your oral arguments? The basic tip is that become comfortable with the record of the case and become comfortable with the facts of the case because the facts of the case should be on tip of your on your fingertips because anytime the judge could ask you to refer to a single paragraph or a single point in the moot court proposition, and if you take some time to actually engross in the facts of the case and actually get down to actually finding where the particular fact of the case is, you could lose a lot of points and a lot of time as well. You should be able to articulate the standard of review applicable to the questions presented and understand the court's latitude with respect to each issue. By this, I mean that you need to anticipate certain questions, such as the jurisdictional questions and also the procedural options for resolving a case. You should be well versed with the questions that the judge is actually likely answer to question you in the court. Because if you are well versed with the questions and prepared beforehand, this would save you a lot of time before the arguments. Secondly, you need to always take into consideration that what does a successful oral advocate's outline look like? So it should be a very short speech, as I mentioned, that it should be a one-page document. But you can always carry a 20-page speech if you're comfortable with that. But if you are taking a longer speech in your hand, you should always be concerned about the fact that what if the judge takes you or drifts you apart from your present argument? Then you will take a lot of time to actually dwell upon your speech to find your arguments. In that case, you should also take a separate pager, which is called a mind map. That I would later on explain you what a mind map is. But let me just briefly explain you what the outline is. So basically, after introducing yourself and the case, and before making any further argument, a competitor should identify two or three issues that he or she will discuss. These issues should be very much clear and straightforward. Often these issues are very much presented in the propositions only. But the opening statement, for example, should go as like that this court should find in favor of the appellant or the petitioner for two reasons. First, this, and second, this. First, because the court does not have jurisdiction, and second, because the customary international law is not applicable in the present case. These are the very crisp opening statements that you want the court to do. Secondly, this should be included in the mind map. Now, let me introduce you what a mind map is. The best tip for ensuring a successful oral advocacy is that you should always carry a mind map. Mind map ensures that flexibility is there within an argument of a moot lawyer. The decision to renounce a weak argument for a stronger one requires flexibility, and if the judge often asks you to focus on one or two points of the argument rather than explaining the entire argument and ignoring the rest of your arguments, you should not panic because this mind map would be very helpful in that case. So, what do you do with a mind map? A mind map can help you quickly navigate in your own readings and address the judge's questions spontaneously. A mind map consists of circle-shaped ovals on a sheet of paper, or you can always make clouds on the paper and actually address your most crucial points and crucial arguments in those air bubbles, or you can say the clouds which you make on the paper. This is a single sheet that I was talking about, which I carried during the moot court competitions. In my mind map, I always keep these things in mind that this is your stronger point and this is my stronger point. So this is the case law that would assist me in approaching the court towards that. You should always be ready with this mind map because you will be often asked to hop around your skeleton. The judge might ask you to address the statement of jurisdiction, but later away he could straight away jump to the merits of the case. He could jump from one fact of the case to another fact of the case. That way, the skeleton always helps you. And in addition to the speech of the case, you can always carry that mind map with you, where you can actually make those short bubbles and create those very much strong points and the strong points of the case, including the case laws and the supportive legislation. That way, you can structure your arguments very well. And apart from that, you can also draft skeletal arguments. By skeletal arguments, I mean that before a moot court competition, before even submitting the moot court memorial, while researching, it is always useful to maintain a document where you collect all the information that you think must go in your memorial. Importantly, you should always be building a skeletal argument for your issue simultaneously. Some prefer to draft arguments while researching, which is something you should do if your memorial submission is already closed. But otherwise, it is always useful to collect your thoughts, prepare a skeletal argument, and get your research in order before drafting the memorial. It is very essential to memorize your opening and your roadmap. The roadmap is the basic mind map that I was mentioning, and it should be always on your tips, the opening statement, as well as the contents of the mind map. Because I understand that it is very much difficult for students to actually learn the speech, which is a 20-page speech. But it is always essential and very much easy to understand a one-page document. That is why my first and the foremost advice is to carry a mind map which includes the skeletal arguments. Now, coming to the fact that how do you create a theme? A successful oral advocate always creates a unifying theme. By a unifying theme, I mean that a central theme to focus and strengthen your argument. A theme will set the tone of your oral argument, and you will want to return to it as your answer the questions from the judges. So, as an advocate, you want to make that theme resonate so that the judges remember your central message after you've left the room. For example, if there is an argument that the international law, the customary international law, is not applicable to the present facts of the case, but the judge takes you to the two essentials of the customary international law, which is opinio juris and state practice. Now, the essential theme of your argument is to prove that there is no customary basis in international law here in the present question. What I mean by creating a unifying theme is that theme is that you need to strengthen on the fact that because of these essentials, customary international law is not applicable on the present facts of the case, and you should stick to the theme even after the judge differs you from that question. So you actually come back to the fact very easily using a mind map. Yes, this is my argument, and this is the case law to support that. You need to always prepare responses to likely questions, like I've already discussed. That you need to always think of what questions you want to answer. Basically, what I call it is that you need to play as a devil's advocate. You should be always concerned that what are the weakest points of your case, and that's what a devil's advocate does. Secondly, what would you have most difficulty responding to, and what questions do you dread and you think that they shouldn't be asked in the court? If you are also prepared in these aspects, the weak points of a case, you will be very much effective in your oral arguments. And if you prepare them well in advance, the judges will give you surely brownie points. Coming on the last aspect in the oral advocacy aspect, the key is to practice. It goes without saying, and everyone knows that you need to practice your oral arguments. While it seems very much obvious, it's one of the most important parts of a preparation. And what I do personally is that I stand in front of a mirror and actually recite my arguments, my opening statements, looking straight at the mirror without reading. Obviously, you need to take your time to read the arguments and in whatever way you can memorize the arguments. You can stick some sheets on your notice board, you can continuously read your paper, or maybe write the speech and actually learn. That's your personal case. But while practicing, you should always take care in mind that if you speak in front of the mirror and discuss your and spend your time with the mirror, you can always structure your arguments very well. You always take care of the fact that the tone of your voice is very much okay or not, and you can take care about the body language as well. That way, you can take care everything by looking yourself into the mirror, and the more you practice, the more better it gets day by day. After practicing the arguments alone a few times, then you can practice in front of a friend or take a video of yourself. Yes, that's very much clear because few of us like us to watch ourselves in a video, but this can be a very great way for you to see yourself and see how nervous or confident you are and correct your problems way before that. My ultimate suggestion for you is that after you are done practicing your oral rounds in front of the mirror, you should always give your oral rounds to a friend before who is not aware of the facts of the case. My purpose of telling you is this because that if you are talking to a layman and actually presenting your arguments to a layman, this would show that how convincing you are to a judge, because the judge is always aware of the facts of the case and the law which is there. But if you are able to convince a layman or a friend before you actually take your oral practice rounds and reach on to the oral rounds before the judge, your convincing power will greatly increase, your flexibility will increase, you will be taking care about all the negatives which were there. You will be understanding that what argument should be there put forward if you can convince a judge forward. So that's my ultimate tip of practicing there. Let me just get down to a couple of questions as to what mooters actually face while they are reaching towards a moot court oral round. So, what is the best thing that an oral advocate can do? Now you are done with your practicing your oral rounds, and the oral round is there tomorrow, and you are just sitting there. watching your speech lying there on the sheet of paper and you're actually thinking of what would happen tomorrow. In that case, people get nervous very easily, and it is very much okay to get nervous. But at the same time, when the ultimate showdown begins, that is the move to ground, you should be always be confident. Even if you are not confident, you should not always say show this on your facial expression, because if you are nervous, even if you hide it from the judge will the judge will always catch you because of your facial expressions. So you should always make your facial expressions very much flexible, and without any fidgeting aspect, because if you it always shows on your face if you're confident enough, and it always shows in your voice of your argument and strength of your argument. If you're not flexible and if you're not confident from the advance, you would always fidget during your argument. And it is very essential to take a break on the very last day. And I always suggest it to my to the teams I've coached, and also I've practiced this with my team in my earlier moot course competition. So what we used to do was that before an oral round, just before the last day, we never practiced. I know it would sound very much surprising that why wouldn't you practice just before 2 days of the round? But what we used to do is that we used to prepare 10 to 20 days in advance, and we used to practice so much that we were so okay with our arguments that, we used to talk while we were talking or maybe sipping coffee, we used to discuss our arguments in the form of a speech. What we used to do as a trick was that to avoid the basic nervousness on the very last day of the argument, we on the very last day before the draw plots take place, when we reach that occasion and when we reach the campus of the college where the mooter competition was to take place, we never practiced. That is my personal tip, and it is coming out of personal experiences. You shouldn't actually try it, but this comes into picture, and you can always try it once you're done getting experience in various mooter competitions, because it solves out your nervousness. Because if you are actually reading onto a thing which you already know again and again, there is a slight possibility that on the very next day you could actually forget it or maybe make mistakes. Which is why we used to take a chill pill on the very last day, and not focus on anything but eat pizzas and everything and chill and relax, because you need a day before the motor competition to balance your mind and actually take care about the fact that yes, you're not at all nervous, you're very much happy with what you're going through. So that's it from my aspect. And the second aspect, which I would end my presentation here, is that you should understand that what is the biggest mistake oral advocates make. The biggest thing that the advocate can do has been covered by me, but the biggest mistake an oral advocate can make is also essential. This also connects with my previous comment as to why you should be confident. The biggest mistake an oral advocate can make is showing nerves or being too formal. Even at the highest levels of authority, for example, if your case is before the Supreme Court of India or in an international moot before the International Court of Justice, an oral argument is closer to a conversation than an oration. I'll repeat that aspect. An oral argument is closer to a conversation than an oration, which leads me to the very first liner that I introduced in the argument, that it is always appreciated that you have a conversation and exchange of ideas with the judge rather than an oration. So if you are being too formal, it also loses you points. You should be very flexible and take the. I know it sounds very much bizarre, but if you treat your judge and your opponents as your friends, and you think that yes, these are only my friends, it always plays a mind game in your map, and you are very much positive, because if you are always concerned about the fact that, oh my god, there is a senior advocate sitting in front of me, how am I going to argue, you will always be too formal, and you won't be that flexible as you are in front of your friends. So always take this consideration and mind that no one is actually there to judge you. This is the ultimate fact of the moot competition, that the judges are not really concerned about how you look or how you speak. They are more concerned about the way you present your arguments and the way you have that convincing power in yourself. It is a learning process, and no one is going to judge you there. So you shouldn't be that formal and show your nerves there. Also, you need to start to give an answer before thinking what to say, because you need to stop for a while and pause for a while before you answer to any arguments. Or advocates often rush into answering a question before actually listening to a question and fearing 2 seconds of silence, because silence is very much necessary. As I said before, judges appreciate if you slow down, and it shouldn't be a matter of fact that you need to complete that speech in a 15 minutes of your allotted time. Even if the speech doesn't get completed, it is very much okay. Before, if you have highlighted all the arguments presented in your mind map, as I already explained you are done with your argument. So it is always better to take a beat to sure you know how what you say before you start speaking. And the most serious error an oral argument is not listening carefully to the questions and thus failing to address the concerns raised by the judge. So making concession is always very much necessary, and becoming confident comes day by day. It is not necessary that you are always confident. I've seen mooters who have done 6 to 7 moots and are still very much nervous before their rounds. And some mooters are very much confident before the very first round. So it's very subjective. And of course, a lot of what I have said today in this piece will be very much subjective to you, or very much based on very specific experiences. But I would advise a common sense approach to adapting what I suggest in order to suit your own style, because every advocate has a certain style. The tips that I presented today on oral advocacy and the advanced oral advocacy are the basic concerns which every advocate should take care of. But ultimately, it is your style, and you should always be concerned about your style, because I've seen voters that do not carry even a mind map and just stand on the podium without nothing in their hand and speak fluently. And they usually win those moots as well. Some participants also win it by a 30-page speech. What I mean by this is that you should always think, introspect, and understand what is your style. And it is also important to take into account any nuances you can attribute to a particular judge or voting situation. Many judges are maybe having completely opposing opinions on the same subject, so you need not be able to read how a judge is responding and adapt your approach accordingly. But you should always be concerned as to what the judges are wishing to, take into consideration. Because as long as you are aiding the judge, you are the best advocate there. Thank you very much for listening to me. That's it from my end, and I wish very best all the budding advocates there and during their all to competitions, because I always say that moving is really fun and it excites you at the very same time. It is a fearful process, but it also excites you at the same time. Thank you once again.